Hey guys, my name is Joel Williams. I'm a personal injury and wrongful death attorney in Kennesaw, Georgia. Today I want to talk to you about Georgia's apportionment statute or comparative fault statute. If this video is helpful to you, we appreciate you liking our page, sharing the video, or just commenting in the sections below. So I know just listening to comparative fault or apportionment sounds pretty boring, but it can have a huge impact on your personal injury case. For example, if you go to trial and the jury awards you $100,000 for your injuries, but the jury says that you're 15% at fault, then the trial court's going to reduce that $100,000 to $85,000, which would reduce your overall recovery. Now, Georgia's unique because in Georgia, non-parties can also be included on the verdict form, which means that if you sue a defendant and then the defendant says there's some other non-party that's liable, then they can be included on the verdict form. So, for example, say you sue ABC Corporation and then ABC Corporation files a pleading and says, well, DEF Corporation is also liable. Well, DEF is a non-party. So practically the way this works is the jury is going to say under that fact scenario, ABC Corporation is responsible for 50% of the damages. DEF Corporation is at fault for 50% of the damages. But because DEF Corporation is not a party, then you are not entitled to recover any of those damages from the non-party. That's why it's so important for attorneys in the state of Georgia or anyone bringing a claim to make sure that anyone that could bear any fault for someone's injuries is included as a defendant in a lawsuit. So another important fact that Georgia plaintiffs or any litigant in Georgia needs to realize is that in lawsuits, if the plaintiff is found to be 50% or more at fault, then he or she cannot recover. So for example, in our previous case, if the plaintiff sues ABC Corp and the jury says that ABC Corp is 50% at fault and the plaintiff is 50% at fault for causing these injuries, then the plaintiff can recover nothing. However, if the plaintiff is less than 50% at fault, say 49%, and then ABC Corp is 51% at fault, then even if it's a $100,000 reward, the plaintiff will only recover $51,000 because ABC Corp is at 51% fault, and the total award is reduced by 49%, which is the plaintiff's allocation of fault. The important thing to remember is that in Georgia personal injury cases, just because the plaintiff may bear some degree of fault, it doesn't mean that he or she doesn't have a case. That's better than other states like North Carolina and Alabama, where if the plaintiff is 1% at fault, they can recover nothing. So if you have questions or if you're worried about bringing a personal injury claim because you may bear some degree of fault, just give us a call here at Joel Williams Law at 404-389-1035 or visit us on the web at gatrialattorney.com. We'll be happy to walk through your scenario, answer any questions you may have, and let you know whether we can help you with your case.